All right, via US history. Welcome back. So, last time we were talking about how the Constitution came about, but today we're going to be talking about the ratification of the Constitution. And the ratification is the approval of the Constitution and it being able to come into effect as the law of the country. Now, as you can see right here, it says that the final approval needed is 9 states to approve the Constitution for it to go into effect and become the law of the land. But how do we get there? So, what we are going to have is these two groups coming into prominence. One is the Federalists, people who value a strong central government, who are in support of the Constitution. You're going to have people like George Washington, James Madison, Alexander Hamilton. And then, of course, there is the flip side of that coin with the anti Federalists, people who value a stronger state government than central government, such as like Thomas Jefferson, John Hancock, Patrick Henry, a lot of prominent figures, right? So, the Federalists, they stress the weaknesses of the Articles of Confederation. It's like we can't function properly if we have this system. We need something stronger. They're going to argue that the Constitution would take care of all the problems that the Articles had. And James Madison, Alexander Hamilton, especially Alexander Hamilton, and John Jay, who was a judge, they're going to publish a series of essays called the Federalist Papers. And if any of you have seen the musical Hamilton, you know that Alexander Hamilton wrote the vast majority of these. He wrote like a good 2/3 of them himself. And these essays, their goal is basically to promote the acceptance of the Constitution, pointing out the issues of the past form with the articles, and saying, like, this is the answer, and this is why. Now, the anti Federalists, who are going to do their own forms of essays speaking against why the Constitution is a good idea, like it's actually a bad idea, and here's why. And they are going to be promoting idea that like we could lose our liberties, and we are also not liking this because there's no Bill of Rights. There's nothing ensuring the rights of the citizens outright. They feared the concentration of power because, like, hey, we just got rid of a centralized government, Parliament, the king. And do we really want to go back to a system of government that has such a centralized power over us again? And so they are thinking, like, yeah, we can be a collection of united states, but our states have the official and final word over things that affect the people who live in the states. That's what they wanted. Now, farmers, they typically fell under anti-federalists, and because they feared the Constitution threatened, the debtor relief laws, which were state funded, and that was used actually to protect a lot of farmers from losing their farms. So, yeah, they also are distrustful of lawyers, merchants, the wealthy class, the businessmen, and that's primarily what is up north, which is like a hotbed of Federalist support. So the Anti-Federalists were primarily in the southern areas, like Maryland on down to Georgia. Now, the two most trusted Americans at this time, George Washington and Benjamin Franklin, they were in favor of ratification. They wanted the Constitution. Frontiersmen, they also had a strong tie for wanting a strong government because, like, hey, we're out on the frontier. States, they don't have the means for being able to come and help us if we need it, but a strong central government that can pool resources from all over the country, yeah, they might be able to do something if we need help. And of course, like the cities, they're going to be in major support of the Constitution as well. So, the Federalist Papers, let's get into that just a little bit more. Federalist Paper number 10 and number 51. James Madison, he's arguing that a strong national government and the Constitution's system of checks and balances would strengthen liberty. It will ensure that the people will not be abused by the government because the branches will keep each other in check. They cannot do anything without approval of the others. And number 78, Hamilton is going to write about the importance of a judicial branch to protect the people's liberties. So, like, the judicial branch, their job is basically to say if a law is constitutional or not, if a law follows and does not contradict any previous laws. Now, they're going to push for fast approval. 5 states had ratified by 1788, but 9 are needed. So to gain support of Massachusetts, the Governor John Hancock, yes, the same John Hancock, he's hinted that he might be picked as the first vice president should he and his state support the Constitution. And the other thing that's going to help gain a lot of approval is the Federalists agreed to add a Bill of Rights to the Constitution because that was something that a lot of anti-federalists spoke that they wanted. So, yeah, that's going to get them the rest of the states that they need for approval of the Constitution into effect. All right, so Congress convenes in New York March 4th, 1789, and they elect the first president of the United States, George Washington, and the first vice president, John Adams, and they added officially the Bill of Rights to the Constitution. The last 2 states, Rhode Island and North Carolina, now reconsidered their earlier rejections and ratified the Constitution, bringing the grand total to 13 states approving. So they all approved. All right. The Constitution is going to establish a representative government based on these 6 principles: popular sovereignty, that the people are the source of the government's power; limited government, that the government has only the powers that the Constitution gives it; separation of powers, that there are 3 branches of government; federalism, that they are federal and state governments sharing power in the country; checks and balances, that each branch of government has the power to limit the actions of the other 2. They keep each other in check and maintain a balance between them. And representative government, that the citizenry who are eligible for voting are able to elect representatives to bring their wants and needs and thoughts and ideas to the government to make laws based on what the people want. Right. Now, the last thing we're going to talk about today is the Bill of Rights itself. We're going to look at each one of them, all 10. And yeah, and the 2 different documents that they are based off of, well, at least partially. So, major principles of the Bill of Rights come from the Virginia Declaration of Rights, which was written by George Mason, 1776, and it outlined basic human rights that the government should not be allowed to violate. So basically reinforcing the life, liberty, and pursuit of happiness from the Declaration of Independence. And Thomas Jefferson wrote a document called the Statute for Religious Freedom, which would basically end the idea of government-supported churches, making it more of a religious toleration being the thing. So separation of church and state, and this is going to be a big influence. So we get, freedom of worship, freedom of religion in the First Amendment comes straight from this. Right, James Madison, he's going to consult the Virginia Declaration of Rights and the Virginia Statute for Religious Freedom when he is writing the first draft of the Bill of Rights, the first 10 amendments to the Constitution. So now let's go ahead and take a look at all 10 of them one by one. Now, the First Amendment. It guarantees freedoms of religion, speech, the press, assembly, like protests, and to petition. This means that we all have the right to practice any religion we want, to speak freely, to assemble, to meet, like a town hall meeting type of deal, and to address the government on any issues we feel are unfair and need to be changed. And also, freedom of the press, that's newspapers, TV, radio, internet. Now, the Second Amendment. This one's getting to be very controversial in years of late. Now, this one is the right to keep and bear arms. Basically gives you the right to own a gun. Simple as that. Now, Third Amendment. This one says no soldier shall in time of peace be quartered in any house without the consent of the owner. Basically, the government cannot force you to house soldiers, like the Quartering Act from before the Revolution, if you remember. Now, the Fourth Amendment, this one is going to protect the people from unreasonable searches and seizures. Basically, the police can't enter your home or search your vehicle without a warrant. The only exception is if, like, say a cop's at your front door and they hear a scream inside, they have the right to bust in and find out what's going on. Or if a cop stops you and there is a gun sitting on the front seat, or they see drugs or alcohol in the front seat, or just out in the open, I should say, if it's out in the open, easily visible, they have the right to search the car then. Otherwise, they need a warrant. All right. Fifth Amendment basically states that it protects people from being held for committing a crime unless they are properly accused. So also that this means that you cannot be tried for the same crime twice. The only way you can be retried on a crime is if new evidence is being presented. And you don't have to testify against yourself, so no self-incrimination. You can't help yourself go to jail. Amendment number 6. This one guarantees a speedy trial. So an impartial jury, so people who don't already think you're guilty, they're neutral on the case. And the accused can confront witnesses against them, so they have the right to confront their accuser and argue their point of view. And that the accused must be allowed to have a lawyer. So think of the Miranda rights. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. That is because of the Sixth Amendment. Seventh Amendment. This one guarantees the right to a speedy civil trial. So, like, if someone is suing you, you have the right for this to be, like, figured out quickly. Criminal trials are when the state tries to convict someone of a crime. That's the difference between the two. And you have a right for both of them to be speedy, really. Eighth Amendment. This one guarantees that punishment will be fair and not cruel. Additionally, that extraordinarily large fines will not be set. So, yeah, that one basically no cruel and unusual punishments. Number 9, powers reserved to the people. Prevents the government from claiming that the only rights people have are those listed in the Bill of Rights. So just because it's here doesn't mean that this is all you get. There are more rights than this. The 10th Amendment, powers reserved to the states. Basically, it protects the states and the people from an all-powerful government, so the federal government can't be abusive, because it establishes that powers not given to the national government or denied to the states specifically, that those powers belong to the states or the people. So, for example, take the legalization of marijuana. The federal government does not take the right to declare whether it should be legal or illegal across the country. that is a power that has been left up to the individual states. So, like places like Colorado, I believe, is one where marijuana is legal for anyone to buy, but Virginia, it's not. That's a state decision. So, there's that example. All right, last slide of this lecture. So, the Constitution and the Bill of Rights, they are the rules that the government must follow to ensure that they are not abusive of the people. This framework, it limits the power of the government and effectively protects the liberties, the rights of the people. All right, that is it for today. Next time, we're going to be taking a look at the Supreme Court and the role of John Marshall in making it as powerful as it is today, in an equal third branch of the government. Be sure to come back for that. Talk to you next time.